As we've gone over in the previous 2 lessons, agency is serious business. And if you don't get it right, it can lead to some pretty major and unpleasant consequences. However, while normally it's enough to follow the rules to stay out of trouble, making sure that you stay above board while engaging in agency relationships is a bit more complex. That whole bit about it being possible to establish an agency relationship simply by implication is the issue. Implication is subjective. So what happens if you inadvertently enter into an agency relationship without realizing it? Or if you believe you're in an agency relationship with a client, but when it comes time to pay, the client insists that no agency relationship ever existed. Let's take a look at the different ways that an agency relationship is established and how one is ended. That way, you'll never find yourself accidentally falling foul of real estate laws, nor losing out a commission because of a misunderstanding. There are 3 main ways that an agency relationship can be created, leading to express agency, implied agency, and ostensible agency. Express agency is the clear-cut version of the agency relationship. It's when the agency relationship has been created by oral or written agreement between the principal and the agent. When a broker and a seller both sign a listing agreement, they have entered into an express agency relationship in which the broker is the agent and the seller is the principal. The listing agreement serves as a contract that clearly lays out the agency relationship and will even put an end date on how long that relationship exists. You might be surprised to find that there isn't a distinction drawn between oral and written agreements, but an oral contract is a legally binding one. Of course, in a court of law, it's always best to have written documents to back up your case. But in real estate, you'll find many instances when there is no written document. In many places, a lot of real estate relationships are initially established with a handshake, and particularly with deals that have smaller stakes, such as residential rentals. It's not always necessary to have a signed agreement. If you're representing a property owner for a rental, there may be other brokerages that are also representing the owner for the same property, and neighborhood landlords might be hesitant to enter into a signed agreement. As long as you agree to act as the agent to the principal and uphold that agreement, including making it clear to any potential renters that you are acting as the agent of the property owner, then you will be engaging in express agency. Now, let's take a look at implied agency. In its simplest terms, implied agency is an agency relationship that is created by the actions of the principal and the agent rather than through any stated agreement that they may have. It is implied agency that can arise accidentally, and it is the kind of relationship which only one party, the principal or the agent, might believe exists, while the other is unaware of there being any agency relationship there. Of course, if the agent is unaware of there existing an agency relationship, then they will likely fail to fulfill their fiduciary responsibility to the principal. And if the principal doesn't believe there is an agency relationship, then they are unlikely to believe that they owe any money to an agent who has dutifully carried out work for them. There are many ways that an implied agency relationship can be created. Let's look at a couple of them. If a friend or acquaintance asks you for some advice in marketing their property, you might want to just help them out. You understand that in order to fully market the property, there's a certain protocol you go through, one that begins with the signing of a listing agreement. But your friend might believe that you are now responsible for selling the property and liable for any advice that you give. Conversely, when your friend asks for help, you might believe they're engaging your services as the selling agent. You might diligently market the property, find a buyer, and while your friend gladly accepts all of your help, at closing, they may not feel like they owe you any sort of commission. Whichever way an implied agency is entered into, it's always best to be avoided. And the way to avoid it is to always make sure that both you and the principal are fully clear on the nature of the relationship. Additionally, to fully avoid implied agency, it can also be important to state when there is no agency relationship in existence. Oftentimes, a potential buyer might take your helpful advice to mean that you are on their side and that you owe them fiduciary responsibility. By making clear that you work for the seller, and while you want to help the buyer, your final loyalty is with the seller, then you are avoiding accidentally entering into an implied agency, which would lead to an undisclosed dual agency. Finally, let's look at the third sort of agency, ostensible agency. Ostensible agency is a specific kind of implied agency, but instead of the principal or agent believing that an agency relationship exists, it is a third party who believes the agency relationship exists. If a property owner knows that you've been driving by their property and mentioning that it is for sale at a particular price to potential buyers, then it would be reasonable for those potential buyers to believe that you are acting as an agent for the property owner. If there is a court case that arises due to this, then the existence of an actual agency relationship can be enforced by the court. In creating express agency, there are two main documents which are used: listing contracts and the buyer representation agreements. While we'll be discussing these further in a later lesson, let's look now at how they are used to establish express agency. While a listing contract has many important components, it establishes an express agency relationship because it lays out what the broker, as a special agent, will do for the seller. All of the agent's responsibilities and expectations in representing the principal will be clearly stated, and the monetary compensation that the principal will owe the agent upon successful completion of a sale is stated. There will also be an end date to a listing agreement, which would cause a termination of the agency relationship, unless there is a sale or extension, and there may be additional conditional reasons that would terminate the relationship included in the listing. A buyer representation agreement works the same way as a listing contract, but it establishes the express agency relationship between the broker as the agent and the buyer as the principal. Because of the important legal consequences of agency relationships, it's important to know how you may terminate an agency relationship. There are 7 main ways in which an agency relationship is terminated. Let's take a look at each one. Number 1, full performance. As a real estate salesperson, the very best way to end an agency relationship is with full performance or completion of the transaction. Once the closing is completed and the job was well done, then the house has been sold or bought, the apartment rented, or the commercial space leased, and you've been paid the commission. The agency relationship is over and everyone walks away happy. Number 2, destruction or condemnation of the property. You know the clause that comes with every airline ticket you ever buy, releasing them of responsibility because of weather or other acts of God. Stuff happens, and whether it's due to an accident, an earthquake, or even negligence, sometimes a property is destroyed or condemned. If you're the agent representing the principal for a property that no longer exists or is severely damaged, then that will be enough to terminate the agency. Number 3, expiration of the listing contract. As mentioned, any written contract will list an end date. And while the principal and agent can agree to extend that time, once the listing contract or buyer representation agreement has expired, then the agency relationship is officially over. Number 4, mutual agreement of the parties. Sometimes things aren't working out, but when there's a written agreement establishing the agency relationship, both the agent and the principal will still have to fulfill their end of the agreement. However, if both parties agree, they can officially terminate the agency. Number 5, breach of contract. Sometimes only one party wants to exit an agency relationship while the other wishes to stay. If the party who wants to terminate the relationship can show that the other party has breached the terms of the contract, then they can have the relationship brought to a close. Number 6, operation of law. There could be an operation of law which supersedes an agency relationship. Perhaps a property is seized as a tax asset by the IRS. In those instances, any agency relationship regarding that property will be nullified. Number 7, death or incapacity of either party. Finally, in the case of death or incapacity by either party to an agency relationship, the relationship is legally terminated.